Dr. Prasad, should we start? Dr. Prasad?
Yes, Dr. Rupa, we can start. Actually, one phone was going on. Shall we start?
Yes, please.
So, good afternoon, friends. On the behalf of the Muktaa Charitable Foundation's Medicolegal Forum, I welcome you all for this today's CME. And let me thank you all for this overwhelming response for this forum, which increased our morale. So we all know that the sole purpose of this forum to start is to help the fellow colleagues in case of any medical legal problem that come up in the clinics, and as well as that the prevention is better than the cure. So not only when you face some problems we will be there, but we want to educate the doctors and make them aware about the possible dangers that they can face in their clinics. So it's a education program also. So we should be well aware before the any untoward incident happen in our clinic. We all know that our website is facing some problem, and we will soon streamline the things. And once again, I would like to thank you for joining this forum, and yeah, you will definitely enjoy this part 2 of the concept of medical negligence. I know. So over to you, Dr. Rupa, please.
Yes. Thank you, Dr. Prasad. Good afternoon, friends. Welcome you all to this Medical Legal Forum, which has been an initiative started by Muktaa Charitable Foundation. As Dr. Prasad correctly mentioned, that this is the forum just to help enhance our practice in the most rational manner, little more fearlessly. If we are practicing in the rational manner, automatically unnecessary fear and anxiety will reduce, correct? To introduce you all to Muktaa, I'm sure most of you are already knowing Muktaa Charitable Foundation well, but still, being the secretary of the organization, let me take this opportunity to walk you through Muktaa's journey in next 2 minutes. So Muktaa Charitable Foundation started in 2005 with HIV helpline in Pune. Though initially it was meant only for Pune, in 2009 we expanded it to Bihar also, and till date in Pune and Bihar together we have covered almost like 4 lakh calls, Piksha Jasta calls. We have catered through this helpline, and on this helpline, along with HIV, over period we have added information like tuberculosis, hepatitis B and C, various other sexual diseases also. Now, while working in HIV helpline and these kind of helpline, we also started the project of addiction related awareness, where we have started conducting sessions for doctors, paramedicals, counselors, in making them aware about various substance and what happens when this substance undergoes some kind of overuse or abuse, and on OPD basis to certain extent how the person can or the professional can manage these cases. What is the role of counseling in these situations? These are the things we conducted for doctors, and even till date, in between, like in 1 year, at least minimum 2 such awareness sessions we do conduct for doctors' medical knowledge updation. Alongside, we also conducted awareness session about addiction in schools and colleges. In 2015, we understood that HIV awareness requires proper medication adherence. Adherence means being sticking to your treatment option, because 100% adherence is very important for the antiretroviral treatment that we take. And that is when we started taking the concern of the children who were just taking the medicines of HIV without knowing their own HIV status. And this issue was little delicate since it required double disclosure. And that is how our Ankur project started, with disclosure of HIV status of the child, of the teenager, of his or her family, then making the child aware about the medication, ART medication, and giving him or her the knowledge of being adolescent. What are the risks involved when any high risk behavior is entertained? So that is how we started with Ankur project. And अंकुर प्रोजेक्ट मध्ये काम करत असताना असं वाटलं की ही इन्फॉर्मेशन फक्त HIV बाधित फॅमिलीसाठीच का म्हणून, तर नॉर्मल बाकीच्या मुलांनाही योग्य प्रकारच्या लैंगिक शिक्षणाची गरज आहे. आणि त्यावेळेस ते विचार डोक्यात ठेवून आपण शाळा पुस्तकांच्या पलीकडे हा प्रोजेक्ट सुरू केला. या शाळा पुस्तकांच्या पलीकडे मध्ये आपण वेगवेगळ्या स्कूल्सना अप्रोच करतो आणि त्या स्कूल्समध्ये त्यांना लाईफ स्किल एज्युकेशन, एडियरन्स हे एडिक्शन बद्दलचं अवेअरनेस, त्याचबरोबरीने वेगवेगळ्या प्रकारे कम्युनिकेशन स्किल कसे स्ट्रॉंग करायचे, आणि लास्ट बट नॉट द लिस्ट सेक्शुअल हेल्थ रिलेटेड अवेअरनेस, या सगळ्या प्रकारच्या अवेअरनेस क्रिएट करायचा प्रयत्न करतो. याच्यामध्ये आपण दिस प्रोजेक्ट हॅज बीन रनिंग थ्रू व्हॉलंटियर्स. सो whoever among you is interested to be part of this Shala project, we do provide a simple small training for that, and you can participate in this project. You can approach the schools in your nearby vicinity or the schools known to you, and that is how you can be part of Muktaa. Alongside, we have, since like working with sexual health, working with LGBTQ community, Muktaa has always been LGBTQ affirmative. So this queer affirmative approach of MCF has promoted gender sensitization related work from Muktaa, which last year we have conducted pan India level वरती जेंडर सेन्सिटायझेशन, म्हणजे ज्याच्यामध्ये एखाद्या टीनेजरला वयात येताना त्याच्या स्वतःच्या बद्दलची जेंडर आयडेंटिटी लक्षात यावी, की मी पुरुष आहे, स्त्री आहे, ट्रान्सजेंडर आहे, बायसेक्शुअल आहे, काय आहे. तर ह्या प्रकारचा, आणि त्याचबरोबरीने स्वतःबद्दलचं लक्षात येणं हेही महत्वाचं आहे, पण दुसऱ्याची जी काही प्रकारची सेक्शुअल ओरिएंटेशन असेल त्याचं रिस्पेक्ट करता येईल. तर ह्या प्रकारचं सेन्सिटायझेशन मुक्तामधून केलं जातं. ह्या सगळ्या दरम्यान आपण सगळ्यांनी कोविड टाइम फेस केला. त्यावेळेला मुक्ताकडून सुद्धा कोविडच्या अवेअरनेस संदर्भातले लेक्चर्स डॉक्टरांसाठी, कॉमन सोसायटी, कॉमन लोकांसाठी सोसायटीज मध्ये वगैरे या प्रकारचे लेक्चर्स घेतले गेले. आणि वेबिनार स्वरूपामध्ये जेव्हा डॉक्टर्स started becoming capable of attending and making use of Zoom platform, attending the webinars, तर मुक्तातर्फे फार्मेकोलॉजी अपडेट, डायबिटीज अपडेट, emergency medicine related update, skill to win kind of webinar, सो असे बरेचसे वेबिनार्स या मागच्या 2 वर्षांमध्ये करत गेलो आपण. आणि याच बरोबरीने हे सगळं HIV, सेक्शुअल हेल्थच्या साइड बाय साइड एनिमिया रिलेटेड विलेज लेवल वरती 3 महिन्यांचे वगैरे असं, जिथे आपण वी आर रिअली वर्किंग टू सी द चेंज, अशा प्रकारे ह्या काम मुक्ताचा एनिमियामध्ये चालू आहे. लास्ट 1 year along with the current running project, last 2 years we have been working with Pratham Foundation for first aid related sessions. We are like serving as subject expert for the volunteers of Pratham Foundation. आणि लास्ट 1 वर्षामध्ये मुक्ताचं काम मेंटल हेल्थ हेल्पलाईन मध्ये वाढत आहे. वी आर अंडरगोइंग recruitments and trainings through which by next financial year आपण त्या मेंटल हेल्थच्या इश्यूजना डील करण्यासाठीची हेल्पलाईन सुरू करणार आहोत. So this was all about Muktaa. Let us quickly now turn towards the Medicolegal forum, which is our main forum. Let us go through this small clip. Yes, Ghanshyam, मुक्ताची एक क्लिप रन करा. Thank you. Thank you. So, Medicolegal Forum. Let me make you all walk through this Medicolegal Forum related benefits, advantages, and the process. Medicolegal Forum, established by Muktaa Charitable Foundation, is to make doctor aware and to guide them in various medico-legal issues related to our day-to-day medical practice. Muktaa Charitable Foundation, this forum is going to clear our doubts with help of our team of medico-legal experts with regular knowledge updation sessions with these experts on monthly basis. Similarly, on a regular monthly basis, we will have certain articles updated on our website on this forum for our reference and use. Personal queries of the doctors will be answered by experts on priority basis. We all will, I'm sure you all must have received the password through which you can make use of these articles from the website. Now, what are the benefits or privileges of for being this group member of this group? We all can attend this kind of webinars and CMEs of this group without any further fees or registration. Basic medico-legal stationery like consent form, certificate format, discharge card, etc. will be provided free in soft copy format on the website. Generic advice will be provided free of cost in any urgent situation of medico-legal nature. This kind of legal advice about other matters like insurance, will, matrimonial, biomedical waste, or documentation, etc., also will be provided free of cost. Individual legal advice like answering notice, complaints in consumer or civil court, approaching summons, statement to police, etc., will be charged depending on the fact of the case, and in the these charges will be most reasonable way to help the participating doctors, and this help will be accorded to direct you to appropriate medico-legal advice according to the situation. Genuine advice against regarding indemnity insurance, both professional as well as hospital errors and omission will be provided free. Defense cost in the court is not covered under medical this membership. It can be facilitated through our indemnity insurance. All confidentiality will be maintained till the final decision has arrived from the court or appropriate authority. It will be nice if we can make use of this group in the time frame of 9 to 1 and 5 to 8, especially if it is going to be done on the call. Of course, urgency, the urgency, emergency basis like violence, threatening, death certificate, postmortem, etc., can be dealt on emergency basis. Now, here, let me also introduce you to the team of volunteers on behalf of Muktaa who's working behind the screen for this. So in the volunteers group, the main core team member and expert, Dr. Jayant Navrange sir, is definitely with us. Along with sir, we have Dr. Padma Iyer, Dr. Prasad Sonis, myself, Dr. Rupa, Mr. Ghanshyam Nanavre, helping us with the technical part, Dr. Gayatri Thatte, Dr. Jayashree Sonis, Dr. Prakash Mahajan, Dr. Amrut Gunteja, Dr. Kushal Mahajan, and Ashwini Shinde, the treasurer of Muktaa. Friends, also let us have know the medico-legal experts in our group. So the main core expert, as I mentioned, Dr. Jayant Navrange sir is there. Along with sir, other experts are Dr. Alka Kupe, Dr. Ashok Shukla, Dr. Dilip Walke, Dr. Girish Kumtekar, Dr. Manish Machwe, Dr. Sugandhi Iyer, Dr. Shiv Kumar Kumbar, Dr. Dhananjay Masade, Dr. Ranade, Dr. Indranil Bawdekar, and Dr. Jagdish Devle, Dr. Milind Savanke. So friends, this is all from my side about Medico-Legal Forum. I'm sure you all must be already receiving the email as well as few updates on WhatsApp. Now, basic procedure about these asking your questions. What we are trying from our side is on the WhatsApp group, we will have request you to put up your question. Within 24 hours, we will try to get those answers from various experts. Now, once we have received the answer from the expert, we will post it on the experts group so that there is unanimity among the experts about the answer. And so approximately this will take like 2 to 3 days maximum, where we will get back to you with your answer. The question and answer will be shared on the group, WhatsApp group itself, so for benefit of others also along with the person who has asked the question. End of the month, all these relevant and important questions we will update on website as question bank from the particular, like question bank December 2022. And over 6 months, once we have the common or overlapping questions, that time we will prepare a common question bank with like first 50 asked questions or something. Now here, it is nice to have your questions on the group, but also I would urge you all to read from the website, from the articles which Dr. Navrange sir and other experts have given on the website, because those articles also will guide us with the basic concepts of medico-legal firm. So I think this is all from my side here. If you people have any queries related to this, you definitely can ask me, Dr. Prasad Sones, or Dr. Padma Iyer madam, and of course to any other volunteer also of the group. So here I request Dr. Padma Iyer madam to take floor. Thank you. मैडम आप म्यूट पे हैं.
Can you hear me?
Yes.
Yeah. Okay. Thank you, Dr. Rupa. Good afternoon, friends. It's my honor and pride to introduce today's speaker, Dr. Jayant Navrange sir, who is my guru and guide, and an expert pediatrician who had excellent academic career, MBBS, DCH, MD in pediatrics with gold medalist. He is honorary pediatrician attached to Dinanath Hospital, Sayadri Hospital, Shrivasta of Sassoon General, Bhartiya Samaj Seva Kendra. He has done LLB. He ranked 4th in the LLB exam. He is an expert, medico-legal expert, giving advice and support to doctors for the last 2-3 decades through medico-legal cell of IMA Pune, and he has helped more than 3,000 doctors. He is vice chairman of medico-legal cell of IMA HQ. He designed the first ever medico-legal course for IMA in 2018. He is also a fitness freak, has taken part in 26 competitive marathons, half and full. He has donated blood 65 times, is a very expert in his accounts, and he has sound knowledge about investments, and he is heading the financial committee of IMA Pune. He is the chairman of IMA Maharashtra State Social Security Scheme since 2018 till now, and is the past trustee of IMA Trust Board. Over to Dr. Navrange sir for his talk on concepts of medical negligence. Over to you, sir.
Thank you, madam, for a lucid introduction once again. And I think henceforth you need not introduce again and again. That will save some time. And thank you so much. And thank you, Muktaa Charitable Foundation, for giving me this opportunity to share my views with the learned attendees. And I think I will be starting straight away with the screen sharing. From my side, I will try my level best.
Sorry. Yeah.
Are you able to see? No.
We can see the Zoom meeting wala page, sir. Maybe presentation.
Presentation is not seen.
Okay. Just hold on. I will restart everything and.
Yes, sir. It has come full screen वरती यायचं बाकी आहे, sir.
Yes, sir. झालंय, done.
Sir, you are on mute.
And slide is also not moving.
I unmuted myself. Sorry. Is it visible now?
Yes, sir.
And am I audible also, right?
Yes.
So we go ahead. So initially we have talked about, in the first part of the talk, a very small introduction was given to the topic of medical negligence. The heart of all the medical legal discussions, not only today, but for any time in our life, whenever we are discussing any problem related to the doctors as far as law is concerned, is the concept of medical negligence. So today's talk is an extremely important one, because ultimately what it boils down to, I'm saying this is correct in 99% of the cases, that it is always assessed whether there was evidence of medical negligence or not on the part of the doctor, and how the courts arrive at that particular thing. There is no separate topic of medical negligence in the textbooks of law. There is a big topic of negligence in law textbooks. These are the laws of civil side, that is called as law of tort. Again, I'm not seeing the slides. Are you seeing the slides?
Sir, please share.
No, sir. No.
परत एकदा sir share करा.
So negligence, is a separate topic in law, but there is nothing like medical negligence separately. So negligence is a big topic. So that is covered by both the civil side as well as the criminal negligence is also there. But we will dissect out the crystal clear definition of medical negligence, though there is no clear-cut definition mentioned in the textbooks of law. So this has been arrived from various decisions on this topic given throughout the world, and it is universally used as of today. And we will see how to see to it that we do not get proved in the medical negligence definition. So once that you are past that particular definition, by and large, you escape any legal consequences. So I'm saying escape, but I would like to defend you. I would like to see that it is given something like a vaccine, that you take the vaccine and you never come across any problems. So that is the way we should be looking at it. I salute all of you. It's only because of the advances and developments in the respective fields that more and more complicated and lengthy procedures, treatments, surgeries, etc. are possible with a good patient safety and outcome. There are many responsibilities. See, you might find that this presentation is more applicable to the consultants and the hospital practice, but then the same concepts are used in the general practice also. And whether general practitioners are affected or not, answer is yes. So nobody is immune. So there are many responsibilities like checking the consent, blood, medicines, etc. before administering those to the patient. Identification of the person, this is very important, even in your day-to-day practice. Invasive procedures. Now, what is meant by invasive procedure?
Sir, may I disturb you 1 minute?
Yeah.
Slide move hot nahi hai pude. We are still on the slide first only.
Is it moving now?
No, sir.
No, sir.
I will stop my sharing.
Yes, you have stopped.
Dr. Upa, can you share the slides from your side?
Should I, sir?
I will send it across to any email you say.
No, you have sent it to me. From there I can.
Yeah, please go ahead.
Yes?
Yes.
Okay, 1 minute. Right?
Yeah, come to the fourth slide. Fourth.
Yeah.
Okay. So, where are we answerable? To whom we are answerable? We are answerable at a Medico to various fora, various commissions, either individually or simultaneously. But the current trend on part of the patients and the consumer activists is to put the cases simultaneously for the same case, for the same facts of the case at multiple legal commissions. So one is your respective medical council. You have the Irish Medical Council or Indian Medical Council. So the case would be taken up there. I mean, any complaint. Then there is a civil or the consumer court. So civil and consumer is same. It is only the procedural part on the civil side is quite complicated, and there is a court fee stamp before a case can be launched, whereas consumer is the civil side only. What is the difference between the two? We'll see again. And consumer is the speedy redressal mechanism. So that is covered by civil law, or also called as law of tort. Now, what is meant by tort? Tort means tortuous. Tortuous act, something crooked, something wrong. So that is what is meant by law of tort. Third is criminal, where the police mechanism comes into action, and this is covered by two important laws, Indian Penal Code and Criminal Procedure Code. Other forums where you are answerable, are human rights commissions, Right to Information Act, statutory bodies like the Pune Municipal Corporation or the Government of Maharashtra or Government of India. For example, right now, measles has been made reportable. So every case of suspected measles or any fever and rash, we have to inform the respective authorities online. So that is a rule or law of the local situation, local government. So we have to inform. So that is what is meant by statutory. Specific laws like biomedical waste disposal, MTP Act, POXO Act. POXO is prevention of child sexual
offense.
child sexual abuse. And last is Janata Darbar. Janata Darbar, people taking the law in their hand and malhandling the doctor, the staff, or the compounder, or trying to destroy your clinic or throw the stones and so on and so forth. Next one. We had this just last Sunday at Lonavala. So why the problem has come now? Because the economy has gone global, all including the doctors will face greater and new challenges. The second part is aggressive consumerism. So a lot of advertisement, a lot of false hopes given to the patients by the indiscreet people who may not be knowing much about medicine. Cutthroat competition, explosive media. Media, I think even in Marathi news channel, there are more than 20 by now. So you can imagine just to grab the TRP, they will give any sort of small news, making into a big item. So that is what I mean by explosive media trials. Then next is increasing cost. To produce a doctor, I need not tell you better because you are much younger to me. So you know the costs are escalating like anything from your education to establishing your own practice. So when the cost is more, it is natural that we have to recover it from the patients. And anything new, the cost is always more prohibitive. And what is the answer to this? Answer to this is vibrant doctor-patient relationship. The doctor-patient relationship, I think it has been tackled to some extent in the past talk also. That remains the fundamental solution. But then rest of the things from legal parlor we'll see. Patience, Shraddha or Saburi, patience and persistence, and good communication. So these are the key points, key areas we have to develop ourselves. Good communication. So vibrant doctor-patient relationships, patience, persistence, and good communication are the key factors which will solve this problem in majority, or I would say almost all cases. And we have to be very gentle, upright, pure-hearted, easier said than done. And I think I have mentioned in the past also, we have to put up in our clinic that please note that information is not equivalent to knowledge, and information, knowledge, and experience makes a wise doctor. So these are not equitable on the same point. So just by reading Google, you should not trouble me that why this is there and why that is not there, and we expect this much. So we should put up this particular board. Information is not equivalent to knowledge and not equivalent to experience, and these three together gives wisdom to the doctor. Ask the history of chronic medication in any patient. I think this was not taught to us. I think Padma Iyer madam will remember that asking about chronic medication has never been mentioned in our regular clinical examination textbooks. It is a very much needed thing these days because so many patients are on different medications. Aspirin, so many people are on aspirin, including some children, anticoagulants, anti-allergic medicines, or long-term anti-rheumatic medicines. So many things are going on. Next one, please. So that history should be a routine part of our clinical history taking. So coming to the definition of negligence is what? A want of reasonable degree. This is from Modi's textbook. That what is meant by negligence? I mean, I'm talking about medical negligence. Simple negligence means any walk of life, want of reasonable care. Easy to understand. But when it comes to definition legally, it says that want of reasonable degree of care and skill. Now, who decides what is meant by reasonable? We'll analyze each of these words. Or willful negligence. I am sure no doctor commits willful negligence, purposeful neglect of the patient, nobody will do. On the part of the doctor, in treating a patient, so while treatment is undertaken, in treating a patient with whom there is a relationship, I mean legal relationship of doctor and patient is established. So what is meant by established doctor-patient relationship? What is meant by not established relationship? We will see in a minute. And these together, so established doctor-patient relationship along with lack of reasonable degree of care and skill leading to damage. So these are the three essential components. So once again, established doctor-patient relationship, lack of reasonable care, and third is resultant damage. And damage can be to the property, to the person. It may end up in death also. But today, most of the cases are including the damage to the emotions of the person, emotions and psychology of the person, mental harassment, and social damage also. So that is where confidentiality part comes. I will exemplify each of these. Next one. So this is a very crystal clear definition. Next, please. And now the concept of deficiency is introduced by the Consumer Act. This is wider than the crystal clear definition of negligence. So negligence, I told you, there are essential components, whereas deficiency is a more generic term which says that anything which you undertook for service, supposing you say that I will visit your home and you don't go at that time, I mean 5, 10 minutes, 15 minutes here and there is okay. But if you don't go there for next 2 hours, due to anything, that may come under deficiency. Or you are saying that my compounder will be looking after collection of blood samples and we have the processing system of blood samples. There is no pathology laboratory, but we have the collection center. And a particular day you are not able to give that service, will amount to deficiency. So deficiency is wider than negligence, but essential heart of the component of these legal cases is definition of medical negligence. Next one, please. So when we are talking about negligence, this is the way it's made simpler for you. Negligence is one aspect only, I mean one definition only. But when you come to understand or learn this particular topic, I would divide this into 2 or 3 important categories. One is the civil category. Civil means tort. Now let us understand what is meant by civil. Civil means also consumer, where if a patient feels aggrieved that something I am suffering because of the some problems done by the patient, doctor, he wants a revenge in the form of compensation, in the form of money. This is covered by civil. Civil decides about the rights. Civil decides about the rights of the patient, rights of the doctor, etc. And whenever that right is infringed means is transgressed, is legally bypassed or exaggerated, then civil right is broken and therefore the other party has to compensate the part who is complaining about the allegation. So that will make good of that particular wrong. That is civil. So civil is essentially the money compensation. Whereas criminal, the aim is very different. Criminal says that the wrongdoer, whosoever has done wrong, should suffer a punishment. And the purpose is different, that not only that person should suffer by taking the punishment, but also should put up a lesson to the rest of the community members. So supposing Dr. Navrange has gone wrong criminally, he should be put behind the bars. He has to take the liability and get the punishment so that other pediatricians will not commit the same mistake. So it is a deterrent action, deterrent purpose. And last is contractual. You make a contract agreement and there is deficiency in that fulfillment of the contract, it will come to contractual. All medical treatments are basically contractual. You will ask me, where do we go about in doing the contract on paper. Yes, contract can be implied and it can be written down, what is called as written agreement. So whenever the doctor is approached by the patient, he asks for management treatment, he wants cure, the doctor examines the patient, he impliedly undertakes the treatment of that patient, and in turn, the patient agrees to pay. That is the completion of the contract. So even if it is not written, this is contractual. Another classification, so one is civil and criminal. I will show one more slide to explain it further. Next is classification is on the basis of whether it is a very gross negligence or whether it is a subtle negligence. Now, what is meant by gross negligence? Leaving the swab in a wound, forgetting to remove one of the stitches where you have put multiple stitches, or leaving the forceps in abdominal cavity during laparotomy, amputating the wrong limb, not checking for anaphylactic reaction when you are giving a drug which is prone to cause anaphylaxis like penicillin or anti-tetanus serum or several other drugs, or for that matter even xylocaine. I am specifically mentioning xylocaine. So not doing the test dose, gross negligence. Not keeping a portable oxygen cylinder in the clinic where you are giving injections, it will amount to gross negligence. I will give you that list, what should be there in the clinic. So these are the cases where it is mentioned that it is not only gross, they say that things, the facts of the things speak for themselves. That means there is no further reason to prove that you're negligent. So that sort of a gross negligence, though it is a principle of civil side, but these cases often go to the criminal side also. Then second is subtle act of negligence, whereas there is a lot of two opinions, or subtle, that means very soft line of demarcation, and there is ample scope to discuss and deliberate and argue on these cases. Now, for example, you and me, all of us agree that we should not be using beta blockers in a case of bronchial asthma because it can precipitate further bronchospasm. So in a case of bronchial asthma with hypertension, the drug of choice is never beta blocker. So I give beta blocker to an asthmatic without taking the history or forgetting the history or without paying attention to this fact. Act of commission. I did something which I should not have done. Or omitting, what did I omit? I omitted to take that precaution to ask the history of asthma. So simple. Another classical example, those who are running the maternity home, doing a cesarean section in a primary parents full-term lady who is having breech presentation. This is a standard indication to do an elective cesarean. You don't do a cesarean section, you attempt a vaginal delivery, and there is damage to the baby or to the mother or both. So you did not do cesarean where you should have done it. Act of omission. Act of commission is you did something, that is vaginal delivery, when cesarean was indicated. Another story, any breast lump, you are subjecting to total mastectomy without doing a full thickness breast biopsy. Act of omission, that you omitted to do a biopsy before doing a radical mastectomy. Whereas act of commission, you did something without a biopsy. So these are the two sides of the same coin. Just to understand, we put it this way: act of omission, act of commission. Next is contributory negligence. That means this is very common in your practice, day-to-day practice, the clinic practice, that you advise something to the patient and they do not follow it. They don't come for follow-up. They don't take the full course of medicine. They do, out of say 7 medicines given to them, they take only the costliest medicines. This is very common. They feel that cheaper medicines will not be benefiting. So out of the 7, I will take only 4. Very, very common, I tell you. I will tell you one story in a nephrotic syndrome where it was labeled as resistant nephrotic syndrome, and you know the treatment of choice is corticosteroids. Now, amongst the medicines prescribed to that child, cortisons were the cheapest, and the costliest were calcium, and then anabolic steroid 1 dose, and then there was protein powder and all those things, they were very expensive. So the parents omitted selectively the prednisolone because it is the cheapest medicine. And he went from one pediatrician to the next to next, and they were planning for a biopsy when the child came to me. And upon detailed history, we found out that how this child must be taking so many medicines. And then I asked them that what medicines are going on, show me. So this prednisolone was not there, Visalone was not there. I said, why did you not take this? Because we thought this is faltu medicine because it is very cheap. So this happens. So contributive negligence means your advice is not getting followed by the patient, and then you can definitely put it. I mean, these things have to be there on the prescription paper. You advise a CT scan, you advise pathology lab workup, and they don't do it. That is a part of negligence on the part of the patient. So that should be very much authenticated, very nicely put on the paper. And non-negligence, I will show you some of the things which appear like negligence because there is a wrong result, but then it is not negligence. Next one, please. This is the difference between civil and criminal side. That criminal negligence is, number one, I would assure you, do not be afraid of arrest. Don't be afraid of the police arrest or here and there, On the civil side, do not worry about loss of practice and adverse publicity. It does not happen. It may affect for 2 or 3 days, but ultimately, usually, it is only to increase your practice. So don't be afraid. Number one, police is a necessary party on the criminal side, whereas it is between the private parties by and large. Of course, government can be a party, but by and large, it is between patient party and doctor's party. Insurance cover is not possible for the criminal side, whereas insurance is possible for civil and consumer side. So please remember, whatever insurance we are going to talk about later on, it covers only civil and consumer side and never criminal side. Third is period of limitation. There is no period of limitation for criminal side. So he becomes a criminal liability till end. Whereas period of limitation is 2 years in consumer cases and 3 years in civil cases. The fourth is the difference between the aim of these two sides. The aim is deterrent. I mentioned to you that it should give a sort of a lesson to the rest of the doctor community that he should not do such type of negligence. So that is a deterrent to do such mistake. Whereas on the aims of the civil side is compensation, money part of it. On the criminal side, it establishes who is the wrongdoer. They have to pinpoint who was at mistake. Whereas on the civil side, it establishes only the rights of that particular patient and whether they were infringed. Section 304(a)(2) saves the doctors to a great extent. That is what I mentioned. Do not be afraid of the arrest. Whereas there is no such need for civil side. Strictest proof beyond doubt is required on the criminal side, whereas only probability is enough. Probability of proof is enough to give compensation. And that is why they go in appeals every now and then. Next one. How much time do I have? Rupa? Ganesham?
सर आपण 5 वाजेपर्यंतचा असा विचार ठेवलेला.
Okay, I will finish before that. Now, again to recapitulate with some examples, is essential components I mentioned to you: establish doctor-patient relationship. Second is act of omission or commission. I am recapitulating again and again because it should get fixed in your mind and heart. The third is test of prudencia. I just passingly mentioned that how the courts come to a diagnosis, I mean, arrive at a conclusion that this particular case has occurred because of the medical negligence. They are not experts in medicine, but they give the judgments. Is it wrong? No. They have the authority and they have the training to give judgments on all walks of life. That means the same judge will take up the cases of medical negligence, also of the criminal negligence, also of the aircraft accident, also in case of disasters, matrimonial, family matters, and the property matters also, and also the murders. So same judge, he is not expert in all these fields, but he can give a judgment. And how does he give it? Here is the Bolam's principle. As far as medical negligence is concerned, Bolam is a principle where how another doctor would have acted in a given situation. So the comparison is done with your own colleagues, what the prudent, that is wise doctor would have acted, sensible doctor would have acted. The test is comparison. So this is Bolam's principle. That is where the opinion of experts come into play. Expert opinion, what does it mention? The expert opinion mentions that I would have done the same way, or this is the standard practice prescribed in the textbooks at that particular period of time. So Bolam's principle in essence is an act of comparison between what the doctor community would have done. Not the topmost expertise is required, not the topmost of the hospitals is required. What is the basic level is always checked. And this is the principle followed by all Indian courts as of today. But there is some change which is occurring, which is more dangerous, which I will tell you in a minute. Next one. Next slide, please. Yeah. And the last one is, sorry, go back. Yeah. And the last one is damage. So again, 4 components, same thing I am saying again and again. Establish doctor-patient relationship, act of omission or commission or gross negligence, that is res ipsa loquitur. Third is test of prudency. And fourth is damage should have occurred as because of the act or alleged act of negligence. Next one. So what is Bolam's test? In Bolam versus Freon, this is UK case, England case, and ECT was given for schizophrenics, which caused fractures. This is way back in 1957 decision. So the case was there of 1952. In that, Justice McNair held that the true test of negligence in diagnosing or treatment of medical negligence is whether the doctor is guilty of such failure that no ordinary doctor or ordinary skill would be guilty of doing it. There can be more than 2 ways of treating, more than 1 way of treating a particular case. But as long as the professional adheres to one which is mentioned in the textbooks, there is no negligence. So there were 2 ways. One to give ECT with muscle relaxant, and the other was give ECT without any muscle relaxant. So this doctor followed ECT without muscle relaxant. Today it is prohibited. But at that time, ECT would be given more effectively without giving muscle relaxant. And that's where the fracture occurred. So it is not negligence. That is what Supreme Court has stuck to this particular principle. Next one. And now the change is, see the second paragraph, Borito versus Hackney, in which it has been mentioned, and now it is getting followed more all across the world, and gradually in India also, last 3 cases have taken up to this particular principle. What does it say? Yes, the Bolam principle is correct. That means you take the expert evidence, but do not completely rely. I mean, this is a directive to the judges that don't go totally by expert opinion, but you have to say whether this expert opinion stands the test of analysis, logical analysis. So ultimately, it is the judiciary which has the upper hand, that they will not go only by expert evidence, but they have to get convinced themselves that expert opinion given is logical. So it is not that just one expert opinion is on your side and the judge will say that you are not guilty. So they have all the reason, but then they have to put down the reason why it is so. By and large, even today, 2022, Bolam's principle is followed. So expert opinion is taken as a final judgment, but there is an increasing trend that judiciary can and does once in a while overrule that. Next one. Now this is a simpler definition given by Supreme Court of India, and this case has come from Pune, and this is the first case decided about medical negligence in a crystal clear way, and that is that LB Joshi versus TB Godbole. And you know this Joshi very well. You know Maharashtra Medical Foundation Joshi Hospital. He was the owner of this hospital. And in this particular case, the doctor lost. Both of these are doctors, Dr. Joshi versus Dr. Godbole. And then in that particular judgment, they have given this particular verdict that, listen carefully, a person who holds himself ready to give medical advice and treatment impliedly undertakes that he possesses the skill and knowledge. So what is meant by skill and knowledge? Knowledge means you have the necessary medical degree from a recognized university and a recognized college and a recognized course. And skill is your updated registration with your respective medical council. So you cannot practice. This is something like driving a vehicle without license. So you have to have proper qualification and the updated registration. So these are the prerequisites. Now such a person, that means a doctor, owes his patients 3 duties. Now what are these 3 duties? Some people are sleeping. It really is pathetic that they have kept the video on. I request them to keep it closed. I don't mind people lying down and listening, but they should keep the video off.
I try to switch
I
it
think they're sleeping. Okay.
Yeah.
So
Yeah.
these 3 duties are a duty of care in deciding whether to undertake the case. So doctor has a freedom to accept a particular case or refuse a case, except in emergency. So a duty of care in deciding whether to undertake the case. So the doctor has a choice. Number 2 is once he accepts that he will like to treat this case, a duty of care in deciding the treatment. And when we say treatment, that means he has to come to a diagnosis. That means history taking, proper examination, appropriate investigations if required, provisional diagnosis, final diagnosis. So all this come in what is the treatment you would like to give to this particular patient. Lastly, next slide please. And lastly is how he will administer this treatment. So every time you are not the person who will be administering every drug and every. Next slide please. So a duty of care in administering that particular treatment with the help of your assistants, colleagues, partners, locums, etc. Any breach of any of these 3 duties becomes an actionable negligence. Actionable means they can go to the courts. So negligence many times happens, but not that every time it stands the test of courts. So you have to define this in these 3 lines, whether the doctor owed the duty, whether he was properly qualified and having the necessary skill. Number 3 is what treatment did he decide, and once he undertakes, how did he administer that treatment? And anywhere there is a lapse of these particular steps, then that becomes actionable negligence. Just hold on for a moment. Hello. Huh. हो हो 1:15 निघा सर 1:15 माझं लेक्चर चालू आहे 1:15 निघा नाही 1:15 निघा सर. So neither the very high nor the very low degree of skill or competence is expected. More the expertise claimed, so more is expected of consultants and super consultants. So level will be always judged as per your qualifications as well as your level of the clinic and of course contemporary era. That means 2022 knowledge will not be applicable to the 2012 knowledge because cases come up very late. What the law expects, I think the red words are very important. Care and not cure is expected. Care and not the cure is expected. You should give care. Cure cannot be guaranteed because it's a healing process, it's a natural process, and it cannot be guaranteed. Next one. So when I come to doctor-patient relationship, doctor has a right to choose. I mentioned this because Supreme Court has mentioned it very clearly. So new NMC rules draft 2022, which has come off. I mean, it is in the draft format. It is not as yet the rules regularly passed. It says that you can refuse a doctor, refuse a patient, even because you had bad experience with that patient or he has not paid your bills. It has been mentioned in the NMC rules and draft. So that's a very big solace, but not in an emergency. Casual telephonic advice not to constitute the relationship, doctor-patient relationship, but that has been changed a bit after telemedicine has been given the sanction. So once you are doing the teleconsultation, it does establish the doctor-patient relationship. Okay, so teleconsultation is established doctor-patient relationship. Once you accept the patient, you cannot leave halfway through. You have started the patient for a case of PO, treatment for a PO. After 3 days, he's not okay, he's not giving your payment. Now I want to give up. No, you have to see to it that he goes to another proper doctor or further care, or you continue treatment. Anesthetists, pathologists, radiologists, they also come into the doctor-patient relationship, though they don't talk to the patient. But on the recommendation of the general practitioner, on the recommendation of the consultant, they take to particular doctors. They are also coming into the doctor-patient relationship. Next one, please. But whenever, next one, please. Whenever, yeah, same slide. Whenever the patient comes to you out of certain compulsion, for example, insurance, you are examining a patient from LIC point of view, or pre-employment, somebody is getting employed in, say, Cutler School, Cummins, and they have particular doctors employed. The patient is not their regular patient, but he has to go to that doctor. Or the new thing that whenever there is an roadside accident victim, there is a court directive that any nearby doctor, irrespective of his degree, irrespective of his level of clinic, he has to give first aid treatment. So when this is a sort of a compulsion, then that is not called as established doctor-patient relationship. तुम्ही तुमच्याकडे कॅज्युअली लग्न समारंभाला गेल्यावर कोणते तुम्हाला विचारायचं बरेच दिवस पोटामध्ये दुखतंय, काय देऊ औषध, that is not doctor-patient relationship. So these are subtle differences. So they have put claims when something goes wrong. याने आम्हाला असं तपासून न तपासता औषध दिलं, but that did not complete the definition of medical negligence because there was no established doctor-patient relationship. Next one. Then gross negligence, I think I already mentioned these cases that things speak for themselves. Wrong identification of a person, amputating the wrong limb, operation theater without a functional suction apparatus, no oxygen, cross-pathy, I will come over this later on, leaving swabs in the wound, they are taken as gross negligence. Rash, reckless acts are sort of criminal negligence, which all these qualify for those gross negligence. Burden of, next one. Next one, please. Then act of omission, I think I already covered these, that not doing the basic investigations for a case of fever of unknown origin. See, 10 days the fever is going on and you don't advise hemogram, X-ray chest, Vidal test, urine test, which are relevant in our situation, that will amount to act of omission. Omitted to give this advice. Or what will be the commission? Treating the patient without investigation. So these both sides are two sides of the same coin. A lot of deliberation, argument is possible. These are good cases to defend. Next one. I think I'll skip this one. Doing the dental extraction without blood sugar testing and so on and so forth. And last is nexus in the alleged act and the damage, subsequent damage. The alleged damage must have resulted as a direct consequence of negligent act. So it is up to the patient to say that this particular suffering is because of doctors not doing it in a proper way. So proof of negligence has to be given by the patient and his lawyer. You are not to worry about that. They have to prove what was the point of negligence. What you have to say is, I had taken all the precautions. This is the contributory negligence. That patient does not comply with your instructions, he is partly or wholly to be blamed. And therefore the compensation can come down. In case there is a claim against us, it will come down to 0 or half of that. So in one interesting case, patient ate very heavy food and had a lot of visitors. Wound gave up. I mean, abdominal surgery was done. It burst open. Death occurred. The advice was, I mean, this particular case was proved in Bihar court that the patient did not listen to our instructions not to eat anything. So this was contributory negligence. Another case, an advocate complained about the wrong dispensing by the chemist and injection by the doctor. He said that the court took a view that advocate should have read it before handing over that ampule to the doctor or the compounder. But these are comparatively rarer cases. I mean, not this, but this type of case going against an advocate is a rare thing. So, but then contributory negligence, it's a good habit to put down the instructions on paper, which is given as a prescription to the patient. So write down the investigation, write down the treatment, proper instruction should be given. Burden of proof is on the patient. But in case the case has occurred in a labor room, operation theater, or intensive care, it is the doctor who has to prove that he has taken all the precaution. Okay, only in these three situations the things change. Next one. Now these are apparent cases of negligence, but they are not negligence in the legal sense. Difference of opinion, it is not negligence. So difference of opinion or wrong result, that means somebody dying or somebody suffering, not getting cured, in spite of proper care, is not negligence. One of the two standards modes of treatment were followed, not negligence. New medicine tried with proper consent, with proper cover of research, not negligence. Patient is not satisfied, is not negligence. He feels that he is not satisfied, usually on the grounds of finances, that is not negligence. No relief despite proper treatment, not negligence. Taking longer time to heal than expected, not negligence. Not taking consent in an emergency, dying patient, and they say that you are not taken the written consent afterwards, it is not negligence. Fees is not a matter of negligence. So charges are your individual charges. I think I will skip this one. Next one. So this is very good statement that Lord Denning has mentioned. He's a very decorated judge. We should be doing disservice to the society if we were to impose liability for everything that happens to go wrong. पेशंटला काही झालं की डॉक्टरचं चुकलंय असं म्हणणं म्हणजे हे सोसायटीवरतीच अन्यायकारक होईल, कारण डॉक्टर्स प्रॉपर ट्रीटमेंट देऊ शकणार नाही. सो वी शुड नॉट जज 1949 ऍक्ट 49 सालची केस असते, मग 54 सालच्या नॉलेज प्रमाणे त्याच्यावर केस घालणं, दॅट इज ऑल्सो नॉट करेक्ट. सो दीज आर देअर जजमेंट्स, unfortunately it is given less importance by most of the local consumer forums. Next one. This is important. What is meant by vicarious liability? Whatever is done by your agent. आपले एजंट कोण असू शकतात? तुमचे पार्टनर, तुमचे लोकम, तुमचे कंपाऊंडर, असिस्टंट्स, आयाबाई, जे कोणी इलेक्ट्रिशियन, जे कोणी तुमच्याकडे काम करतायत, सबऑर्डिनेट्स ज्यांना तुम्ही नेमलंय, त्यांची सिव्हिल लायबिलिटी आपल्यावरती येते. त्या क्लिनिकचा जो चीफ असतो त्याच्यावरती येते. सो दॅट इज द प्रिन्सिपल ऑफ रिस्पॉन्डंट सुपिरियर. So this is only a civil side. It cannot be applied to criminal side. That anything done by your subordinates, contractors, employees is the liability of the principal employer. क्लिनिक मधले अशा 2-3 केसेस मला बघायला मिळाल्या की ज्या ठिकाणी इंजेक्शन नर्सने दिलं, इंजेक्शन आपण ट्रेन केलेल्या व्यक्तीने दिलं किंवा कंपाऊंडरने दिलं, चुकीचं औषध त्यांनी डिस्पेन्स केलं, the liability has come in a big way on the doctors. So be careful whom we are employing or whether they are trained or not. Keep a watch on their functioning. So कित्येक असे एक्झाम्पल्स आहेत. एक ग्लेअरिंग एक्झाम्पल मी देतो. हा हरजोत सिंग फेमस केस आहे. हरजोत सिंग अहलुवालिया 4 वर्षाचं पोरग टायफॉइडने ऍडमिट होता आणि क्लोरोफेनिकॉल वॉज गोइंग ऑन इन अ दिल्ली हॉस्पिटल. दिस इज स्टील अलाइव्ह. दिस पर्सन इज स्टील अलाइव्ह. सो दिस इज अ 1997 केस. आणि त्याच्यामध्ये तो 4 वर्षाचा पोरगा 4था दिवस ट्रीटमेंटचा चालू होता. क्लोरोफेनिकॉल वॉज टू बी गिवन. द नर्स ती घाईमध्ये होती, चुकून तिने क्लोरोक्विन लिहून दिलं. क्लोरोक्विन खालच्या दुकानात आणून त्या नर्सच्या हातात दिल्याबरोबर शी गिव्ह द इंजेक्शन इन द आयव्ही ट्यूबिंग अँड द चाइल्ड बिकेम इन्स्टंटली कार्डिओरेस्पिरेटरी अरेस्ट. ही वॉज रिवाइव्ड बाय इंट्युबेशन आणि आता तो ब्रेन डेथ झालेला आहे. द पर्सन हॅज बिकम व्हेजिटेटिव्ह. आणि अशा केसमध्ये जे कन्सल्टंट ट्रीट करत होते, हॉस्पिटल ट्रीट, त्यांची काही चूक नसताना, कोणतीही चूक नसताना हॉस्पिटलला कॉम्पेन्सेशन, त्यावेळेचं हायेस्ट कॉम्पेन्सेशन 17 लाखाचं होतं, ते द्यावं लागलं. आता हीच कॉम्पेन्सेशन 1.7 करोडची असतात. तेव्हा फॉरगेट अबाउट द अमाऊंट बिकॉज दॅट कॅन बी कवर्ड बाय इन्शुरन्स, बट देन द लायबिलिटी कम्स ऑन द प्रिन्सिपल पर्सन हु इज एम्प्लॉइंग और रनिंग द शो. नेक्स्ट वन. And these are your defenses. So what are the points of defenses? Mistake or misadventure. एखाद्याला वाचवताना तुम्ही त्याच्या पलीकडे जाऊ शकता. कुठेतरी डॅमेज आता उदाहरणार्थ आपल्याला माहिती आहे सीपीआर आपण देतो, सगळ्यांनी सीपीआर ट्रेनिंग घेतलंय मला वाटतं, ते सर्टिफिकेट जपून ठेवा सीपीआर ट्रेनिंग. नाउ दिस सीपीआर ट्रेनिंग वन्स इट हॅज बीन mentioned and told that there can be fracture of the ribs, fracture of the rib at the time, sternal junction and rib that gets dislodged. So this can occur. You are trying to save. That is not negligence. It can occur. Mistake or misadventure is not negligence. Inherent risk in the management. कुठेही आपण ट्रीटमेंट देत असताना त्याला टू साइड्स ऑफ द वेपन आहेतच. So there can be some untoward reaction or untoward happening. But if it is done correctly with proper evidence, it is not negligence. Valencia in non-fit injury. म्हणजे पेशंटला आपण सांगितलं इंजेक्शन द्यायला पाहिजे. Injection is an invasion in the body. You have to have a written consent. Now you will ask me whether it is to be done every time. It is not possible. Then we should have a case record. At least when they come for the first time, we have to take a general consent that we might be requiring to give injections to you, and it is taken for granted inherently that you are allowing me to use that weapon. So every time written consent need not be taken, but otherwise at least once it has to be taken. So these are some of the newer concepts which you have to adopt to these changes. Acts done in good faith. आपल्या सगळ्या ऍक्ट्स असतात त्या गुड. आपण कुठेतरी इंज्युअर करत असतो पेशंटला, तपासताना, डायग्नोस्टिक टेस्ट करत असताना, इंजेक्शन देताना, आयव्ही लावताना, सर्जरी करताना. सो दीज आर डन ऍक्ट्स डन गुड फेथ. नाहीतर दुसऱ्याला टच करणं हा सुद्धा गुन्हा आहे. ऍक्सिडेंट, you are doing some cancer surgery and some accident occurs within the abdomen and aorta gets torn, that is not to be taken as negligence. Taken all the आपण सगळे precaution घेतल्या. Is it negligence? No. You have to take precaution. What is required is to take care and not, you are not undertaking the cure. Then period of limitation, check the period of limitation. 2 years and 3 years I already mentioned to you. Contributory negligence I already mentioned to you. Error of judgment test पुन्हा थोडंसं सेकंड ओपिनियन किंवा सॉरी डिफरन्स ऑफ ओपिनियन मध्ये येईल. माझं जजमेंट त्यावेळी असं होतं. सी टीबी, दीज आर स्टील व्हेरी डिफिकल्ट केसेस. ट्युबरक्युलोसिस, when it is extra pulmonary tuberculosis, these are difficult cases to diagnose. Acted adequately and on sound scientific ground, not negligence. So we should be able to explain the logic. Next one, please. Next one, please. I think I'll skip this one. Next one. So all can make mistakes, but all mistakes are not negligence. And even the most senior and the learned one about to retire, they can prove to be negligent. If you diagnose something brilliantly, don't take a credit. But if you miss something, take it seriously. This negligence case can be your first case at any period of your practice. But if it occurs in the first 5 years, it becomes a real big problem. So it may be your first negligence case, but it is not pardoned. Even if it is, the intention is good. Next. So in short, I think I have mentioned this in my previous talk also. If one treats his patients as if he is treating his dear and near one, something like your father, mother, brother, sister, cousin, nephew, or a good friend, chances are very negligible that you will be proved negligent. So every patient, you should take it as a very near and dear one to you. Revise your diagnosis if there is no relief. Mind your behavior. These are the important things. I will come to those again, maybe at in next 2-3 minutes. Next one. I think I have covered this last time, so but an important slide. So we can skip this one while discussing, but these are very important. Next one. Next one. These are the difficult P's. So whenever the patient belongs, so ask about their profession. I mean, what they are doing. Press people as patients, politicians, poor people. Poor म्हणजे मी poor आणि अडाणी किंवा अडाणी असल्याचं सोंग घेणारे. पोलीस ऍज पेशंट्स, फार्मासिस्ट ऍज पेशंट्स, कारण ते अर्धवट औषधं घेतात, स्वतःला फार माहिती असं समजतात. प्लीडर्स म्हणजे लॉयर्स. दीज आर डिफिकल्ट कॅटेगरीज ऑफ पेशंट्स. अँड NRIs plus one red N, NRIs. These are, you have to be extra careful. I think important judgments is a separate talk. Will not take it at this stage. Just skip 2 or 3 slides here. And these judgments have proved the definition of medical negligence. Next. Next one. Next one. Yeah. So, now pay attention to this. Emergency equipment which is desired, and there is one judgment in which the Supreme Court has mentioned these things, that every clinic, I'm mentioning every clinic which gives injection should have these things. So my sincere request to all the listeners today is that you can prepare a group, get them in a bulk, and keep them in your clinic, at least to make a show that you have the airways, the mouth gags, 14 and 18 standard gauge needles, umbu bag, a laryngoscope, ET tubes, that is endotracheal tubes, or at least laryngeal mask. I know you have to take separate training for this, but at least keep them ready in the clinic. Somebody else coming to your rescue can help you. It may be required once in lifetime, but if you don't have them, it becomes a very big negligence. And this has been mentioned in one of the judgments on the basis that they asked the medical councils what should be the minimum equipment required in an OPD. This is what is mentioned: portable oxygen, IV line, scalpel needle or intracats, connecting systems, IV tubings, syringes, fluid. आता मला माहिती आहे की यातलं खूपसं एक्सपायरी डेट होऊन वाया जातं. इट इज वर्थ द एक्सपेंडिचर. आपण जेव्हा हॉस्पिटलही चालवतो तसंच क्लिनिक चालवायला पाहिजे की वर्षाला 1000 रुपये आपल्याला ह्याच्यासाठी वाया जाणारे समजून करायला पाहिजे. ते नाही वापरायला लागलं तर आनंदाची गोष्ट आहे, सेलिब्रेट, पेढे वाटा, परंतु आपल्याकडे तयार पाहिजे. Contact number of ambulances, contact number of your friends, doctors, hospitals and nearby ICUs. Next one. So some suggestions from my side are: check the history. Do not go by the patient's assurance that current reports are okay. तुम्ही स्वतः verify करा. Check the BP yourself. Check the blood sugar yourself. Have the blood pressure apparatus and glucometer with strips. Take the informed denial. जर एखाद्या पेशंटने हे करायला नकार दिला किंवा काही करायला नकार दिला, टेक डाऊन इन रायटिंग ऑन द केस पेपर आणि त्याची सही घ्या त्याच्यावरती डिनायलची, की मी हे सांगितलंय पण मला नाही करायचं. कीप द रेकॉर्ड फॉर 5 years, एस्पेशली मेजर केसेस. कन्सेंट, मी तुम्हाला सांगितलं कन्सेंट बद्दल, तो एक सेपरेट टॉक आहे, आपण पुन्हा कधीतरी कव्हर करणार आहोत. Incomplete interpretation of reports is negligence. Incomplete. So whenever you're advising, check the reports thoroughly, understand them, or call your pathologist colleague that what is the meaning of this particular report. Leaving the patient to untrained staff will be negligence. False claims, मी हे पण बरं करतो, ते पण बरं करतो, it's also taken as negligence. Next one. Next one. So some of the guidelines, I will just take 3 minutes more. Keep a copy of these 2 judgments. I think it is there in the last slide once again. So these, I think I've taken the next slide only. Next one. Yeah. Adjust the records well in time. आपल्यावरती काही जर प्रसंग घडला असेल किंवा काही तुम्हाला शंका असेल की हा पेशंट कटकट करणार आहे, रेफरन्स मध्ये पण लागतं. रेफरन्स नोट आपण दिलेली असते, त्याची कॉपी आपण ठेवत नाही. रेफरन्स नोटची कॉपी ठेवणं आवश्यक आहे. ओके, विथ सिग्नेचर की मला ही नोट मिळाली. Adjust the records well in time. Take the help of the medico-legal experts in time. Be a life member of IMA or any such similar body. Do not succumb to any pressures for a wrong cause. Next one, quota certificate diu naka. Be polite and sweet-tongued. Call your colleagues in time if there is any perceived crisis. No cross-pathy. Now I will dwell upon this. What is meant by cross-pathy? आणि तुम्हाला तुमच्या बद्दल खूप संभ्रम पण असू शकेल. BMS and Ayurvedic graduates can practice allopathy in Maharashtra. That is as per the 1992 GR. So that is number 1. So BMS लोकांचा प्रश्नच नाही. Now the question comes about homeopathy. The case is in the High Court of Bombay. Case घातली गेलेली आहे, परंतु स्टे दिलेला नाहीये. So whether they can practice, so it depends what the homeopathy council has said. Previously they had given in writing that we have advised our graduates, registered doctors, not to use anything else but homeopathy. That is there black and white. It is in crystal clear words. So once they use something else, it becomes an offense. But now I have been told that homeopathic council has come out the other way around. So once the council says that they can use it, and if it is there in the curriculum, the allopathic subjects are there in the curriculum. Allopathic system is also there in the curriculum, because Ayurvedic people have put it that way. MD anesthesia, MD gynecology, MS ophthalmic surgery into bracket Ayurvedic. They have taken both syllabuses, Ayurvedic and allopathic. So it is now 100% sure. I have seen the MUHS curriculum that they can use allopathy. Of course, everybody should pay attention to their restrictions, in the sense that whatever they have not expertise or not experience, they should not do it as an experiment. But then, if it is in the curriculum, if their council says, and if they have taken a training, they can use these drugs. About homeopathy, there is some controversy, and court has not given stay for homeopaths to be using allopathy. So till the time that comes, use it judiciously and in simpler way, but preferably I would say don't use them, because there is a very glaring Supreme Court judgment, and later on so many changes occurred, but diagnostic facilities can be used by all. Now we will, some questions will be there. It will be separate topic. We will dwell upon it in a separate talk, but there were some discussions on the group that I was told. So I'm just mentioning here that we will restrict it to these two important categories: allopath separately, BMS they can use it in Maharashtra, and about homeopathy to the extent their syllabus says. Okay, so please ask for any query by email. Be truthful in details. It will be attended to, and unite and cover each others ethically as far as possible. Next one, last 1 or 2 slides. Doctor should not go by the patient's version alone. Experiment only if it is accepted and you have taken a written consent. Takes expert opinion as and when required. Full record of diagnosis treatment should be maintained. Next one. Do not hand over the papers to anybody. I mean, anybody means any third party. It should be given only to that patient or his next of kin with the permission of that patient. Next one. I think I will stop over here. This covers completely the topic and concept of medical negligence. And then there are so many other aspects attached to this, which we can cover in subsequent monthly seminars. Thank you very much for a very patient listening. And I see some questions which have come. We can take them up. Yeah.
Yes. Thank you very much, sir, for this very informative talk. You precisely focused on what is negligence and what is not negligence. So thank you for that. And we have 3-4 questions in the chat box. We'll take that. So the first question is the denial to give a death certificate for home visit, is it a negligence? So can we say no to the death certificate for non-compliant patient or our non-regular patient, we can say?
No, I didn't get the question completely. The patient was under somebody's care.
Yeah.
And he did not listen to your advice. The person dies.
What is mentioned in this is a denial to give a certificate for the home death, and it's a non-compliant patient that is mentioned. Non-compliant.
So yeah, non-compliant means he is not obeying your orders and not.
Yeah.
नाही सर, काय होतं की शेजारी वगैरे असतात ना, तर ते आपल्याला बोलवतात की आजोबा आहेत किंवा असं आहेत, तर दे कॉल अस अँड की तुम्ही डेथ सर्टिफिकेट द्या. त्याच्यासाठी म्हणून तसा प्रश्न आहे तो.
म्हणजे जे तुमचे आधीचे पेशंट नसतील ते.
हा, नसतील किंवा ओळखीचे आहेत. दे आर नॉट राईटली डायरेक्टली विथ अंडर अवर ट्रीटमेंट.
ओके असं. ओके. नाही, त्याच्यामध्ये मला असं वाटतं मॅडम, याच्यामध्ये थोडं तारतम्य बाळगायला लागतं. स्ट्रिक्टली स्पीकिंग नो. इफ इज नॉट युअर पेशंट डोंट गिव्ह. हे म्हणायला सोपं आहे, पण नेक्स्ट डोअरच्या पेशंट मध्ये म्हातारा गेला आणि आपण डेथ सर्टिफिकेट दिलं नाही तर आपली ह्युमॅनिटी, आपली माणुसकी निघते याच्यामध्ये. सो इफ यू आर शुअर दॅट देयर इज नो फाउल प्ले, you can give a cause of, you can give a death certificate and talk to the doctor who was treating की तुम्हाला ही खात्री आहे ना हा पेशंट कसला होता वगैरे वगैरे, then you can give a cause of death.
So the next question is, can we deny home visit? Is it negligence?
No, you can deny home visit. You can. Home visit is not the right of the patient, so you can deny.
Does the verbal consent is granted in the court of law? Verbal consent.
फार चांगला प्रश्न आहे. तो कन्सेंट मध्ये आपण घेणार आहोत, परंतु व्हर्बल कन्सेंट घेऊ म्हणजे रिटन कन्सेंटच घ्या असे सुप्रीम कोर्टाचे डायरेक्टिव्ह आहेत. त्यामुळे व्हर्बल कन्सेंट आता पुरणार नाही. फक्त तपासणी पुरतं ओपीडी लेवल पुरतं पुरेल.
Sir, you must be knowing that the government has come up with the CCMP course for the homeopaths. So after completion of the course, whether they are advisable to use the allopathic practice?
आता त्याच्यात काय आहे, थोडस गफलत आहे त्याच्यामध्ये. काय बारकाव आहे तो मी सांगतो. सीसीएमपी कोर्स केला, पण त्याच्यात पुढचं वाक्य असं आहे की दे शुड गेट रजिस्टर्ड विथ द मेडिकल काउन्सिल ऑफ इंडिया, म्हणजे आता एनएमसी. दॅट इज नॉट स्टील अलाउड. So as long as they are not on the what I can say list of RMPs of the Medical Council of India, तोपर्यंत त्यांना ॲलोपॅथी वापरता येत नाही. पण on the same basis, if they come out with a proper GR, I think the answer would be something like GR for BMS people in 1992. अनंतराव थोपटे त्यावेळेला होते आरोग्यमंत्री. तशा पद्धतीचा GR काढून घेतला ना तर सगळ्यात सोपं जाईल. Then they can practice allopathy to the extent they are trained. पण otherwise निदान सोप्या केसमध्ये ज्या औषधांना फारशी साईड इफेक्ट्स नाही आहेत, दे कॅन यूज इट.
Also, you said that we should take consent before injection. So we use the diclo and many other injections on the OPD basis.
माझं suggestion, I think this will be good addition to our members, that we will prepare a proper consent for any injection and we should put it into the family folder of every patient. जेवढे तिथले ऍडल्ट हे असतील मेंबर्स किंवा इव्हन चिल्ड्रनच्या वतीने त्यांच्या ऍडल्ट्सनी हे उत्तर कन्सेंट द्यायचे, ते एक आपण तयार करूया आणि ती त्यांनी केस पेपरच्या जोडून ठेवावी. इट इज कॉल्ड एज अ परपेच्युअल कन्सेंट. सो वी शुड हॅव इट. आणि डायक्लोफेनाकला तर घ्याच, वर्स्ट इंजेक्शन.
सर बऱ्याच वेळेला म्हणजे प्रत्येक ऑपरेशनच्या वेळी हॉस्पिटलला प्रत्येक ऑपरेशनच्या वेळी कन्सेंट ही घेतली जाते. आणि इफ एनिथिंग गोज रॉंग ऑन टेबल, the relatives go in the consumer court. So अशा वेळी ही कन्सेंट स्टँड होते का कोर्ट ऑफ लॉ मध्ये आणि त्याचा काय सिग्निफिकन्स?
छान प्रश्न आहे. हे सगळं आपण कन्सेंटच्या वेळी घेणार आहोत, परंतु एक लक्षात घ्यायचं, टेकिंग अ ब्युटिफुल कन्सेंट इज नॉट अ लायसन्स टू कमिट नेग्लिजन्स. ओके, आपण कन्सेंट खूप डिटेलमध्ये घेतली, कागदपत्रे 9 पानाची घेतली, पण तिकडे काही नेग्लिजन्सची डेफिनेशन मी आपल्याला सांगितली. ते जर झालं तर कन्सेंट इज नॉट प्रोटेक्टेड. दॅट इज नंबर 1. आणि नंबर 2, कन्सेंट इज नॉट गिव्हिंग यू लायसन्स टू कमिट नेग्लिजन्स. पण कन्सेंट जर घेतलीच नाही तर प्रायमरी नेग्लिजन्स होईल. म्हणजे कन्सेंट न घेणं हा गुन्हा आहे, पण कन्सेंट घेऊन नेग्लिजन्स केला तर सुटतो का? नाही.
सर बऱ्याच वेळेला कन्सेंट म्हणजे जेव्हा एखादी केस फाईल होते तेव्हा कोर्ट ऑलवेज ॲडवाइज्ड डॉक्टर्स टू गो रेफर द केस टू द एक्सपर्ट्स. म्हणजे एक रिव्ह्यू कमिटी असते, त्याच्याकडे ती केस जाते. तर या रिव्ह्यू कमिटीमध्ये कोण लोक असतात?
रिव्ह्यू कमिटीमध्ये 4 लोक असतात. कन्सर्न म्हणजे मुलगा असला तर पिडियाट्रिशियन एक असतो, लहान मुलं असलं. ऍडल्ट मेडिसिन केस तर फिजिशियन असतो, म्हणजे प्रोफेसर ऑफ पिडियाट्रिक, प्रोफेसर ऑफ मेडिसिन. जर ती केस सर्जरीचा असतो तर ज्या कुठल्या ब्रँचचं ते असेल त्याचा प्रोफेसर असतो. एक प्रोफेसर जनरल मेडिसिनचा असतो, एक अनेस्थेशियाचा असतो आणि एक फॉरेन्सिक डिपार्टमेंटचा असतो. सो हे 4 लोक त्याच्यामध्ये असतात.
I think there are no more questions in the chat box. Padma madam, do you have any questions?
No questions in the YouTube link.
Yes.
Also. No question.
Yes, ma'am. Yes, ma'am. Thank you. Okay. Sir, thank you very much, sir. Now I request Dr. Mahajan sir to please summarize the session.
Yeah, thank you very much, sir. I think so many things have been clarified by you today. So many things, as usual, they are clarified by you today also. So I always had a doubt, how a lawyer can give a decision, or a judge, he can give the decision on the doctor's behavior, because medicine itself is so complex. Medicine itself is so complex that how can a lawyer give when you talk about that Boland's prudence test, where a comparison of how a wise doctor would have acted in that similar situation, I think that clarified to me very clearly. Secondly, the whole summary of the whole lecture will be you can never be too overcautious. You have to take cautions every time, because you don't know about the law. the whole legal system in the whole of the world, I think, is very tortuous, very complicated for doctors to understand. And the court, if you think it's a little it is non-negligence, but the court might say it is a contributory negligence or a gross negligence or whatever. So it is always better to be overcautious. We are totally alien to this world of law. And that's why we should always take care. Anything can happen anywhere, anytime. So, and if you want to prevent your clinic to become a Janta Darbar, have a very vibrant doctor-patient relationship. And I think that helps in most of the times. Thank you very much, sir.
Thank you.
Thank you all.
Thank you.
Right. Thanks.
Thank you, sir.
Thank you. Thank you, Navrange sir, Prakash sir.
Thank you, sir. Thank you.
Thank you for all the participants for joining the session.
Thank you, sir.
Thank you.
It was
Yes.
wonderful.
Thank you.
Thanks. So we will end the meeting.